Well, hello, and welcome. I'm glad you could join me today as we tear down the NFA one piece at a time. Now understand, my videos are pretty hot right now with anti-gun people. They're watching me with a magnifying glass because they know the NFA has never been ruled constitutional. There is no Supreme Court standing in that. Should a case make it up to the Supreme Court, the NFA will most certainly fall. And I see them attacking particular viewers when they bring up little nuggets of information and points of this or points of that using terms like jailbird lawyer. You guys know the suspects. Understand. Everything has changed. So, June 23rd, 2022, which is not even 4 months ago, the entire landscape of this country has changed. Why, you may ask? And what has changed? Well, see, the thing was, there was a term called jailbird lawyer, jailhouse lawyer, convict lawyer, stuff like that. It was basically somebody would get locked up and they would start looking into specifically around gun charges like, hey, the Second Amendment clearly says shall not be infringed, and then they find all these supporting documents and they try to get their lawyers to present it to the courts. But it didn't really matter because the courts simply said, yes, we understand this particular law is incredibly unconstitutional. However, balancing that on public interest, well, we're going to let it stand. So instead of text, history, and tradition be important, what was important with those cases are how to interpret what the ATF and or Congress had said. So instead of looking at what is constitutional, they would have to look at like, okay, so in this particular opinion letter, the ATF said this. We believe it should be interpreted in this light. Congress had said this about this particular topic, so we believe it should be interpreted like this, and that's what they would argue in court. Because they would argue, did you or did you not commit the crime? And what is the interpretation of Congress and the ATF's laws? Well, unfortunately, June 23rd, 2022, we finally got a Supreme Court ruling. Yes, there was other ones like Miller, Heller, stuff like that that helped reaffirm the Second Amendment. But the Bruin decision itself was a huge thing because they're like, they didn't come out and say it, but what they alluded to is Congress did not have the power to pass the NFA, the GCA, or any of the thousands of gun restrictions that are out there. I don't want you to balance it with public interest anymore. I want you to strictly look at the particular law. Is it or is it not constitutional? And come to this decision by looking at text, history, and tradition. Before June 23rd, 2022, realistically, any lawyer could have handled the gun case. They really could have. However, now that text, history, and tradition is important, you want specifically a firearms lawyer. Somebody that lives, eats, and breathes gun laws, Constitution, the history of the Constitution, stuff like that. Because it's incredibly important. Because what matters now is like the definition. So back in the 1700s, or the 1800s, or anything before 1934, what exactly was the definition of X, Y, or Z? Laws around that time. What kind of laws were in there? What type of historical tradition do we have with restricting particular firearms? Examples. Like, okay, so XYZ owned XYZ. Here's a historical example. There is no sort of restriction. There was no law against that. So let's keep going. So for an example, we're going to talk about SBR versus pistol. So let's pretend that you got arrested on an SBR charge. They have determined your rifle is a short barrel rifle. It does not qualify as a pistol. So you would be looking for examples of pistols with stocks before 1934. And you would find them from anywhere from, I'd probably go 1970 or 1791 all the way to 1934. I'd pull up a bunch of pistols with stocks, be like, hey, there's no restrictions on this. And then I'd pull up the historical definition of what a pistol is. Does it need to fit in a holster? What defines it as a pistol? Because especially with SBRs, that's really, really murky water. Because what is the difference between a pistol and an SBR? There really isn't one. It used to be if it was over a certain amount of length, and if the barrel was so long. But really, does that separate the difference between a pistol and a rifle? And even if it does, where is there some sort of historical law that says you can't have an SBR before 1934? Because we're looking at the overall landscape of the country, the hundreds and hundreds of years, not the past, not even 100 years yet. Now, like I said, jailbird lawyers, it's important, especially if you don't have a specific firearms lawyer like, I don't know, Matt from Fudbusters.
And I want to talk about just one of them today. No, not that one. Stop asking me about that one. I have not worked there for months, and I cannot answer any questions about what is or is not being tweeted, twatted, or twote.
Somebody that knows firearms in and out. Not just a lawyer that can argue ATF and Congress's definitions, because they didn't have the power to restrict the Second Amendment. Congress is specifically limited to the power granted to them by the Constitution. There's a specific section for firearms in the Constitution. Everybody knows it says the Second Amendment. So exactly what power is afforded to Congress in the Second Amendment? Well, it says right at the end, shall not be infringed. AKA, they are afforded zero power to making any laws whatsoever against the Second Amendment. As a matter of fact, the 14th Amendment even backs that up. If you go against the Constitution, like you lead a rebellion, like say you get a group of people together to try to attack the Second Amendment, you're not eligible for office anymore. Like, that's how cutthroat and restrictive the Constitution is on Congress's power, especially around firearms. So, in 1934, when they passed the NFA, did they have the power to do that in the first place? The answer is no. No, they did not. So what's going to come up is they're going to bring up historical gun restrictions. Specifically, they're going to talk about the Black Code. That is a big one. Now, it is important that your lawyer knows, and if this comes up in court, you're like, hey, just so you know, this is it. Because you don't want your lawyer to get tripped up and the judge to believe that, yes, there is some sort of historical context behind gun restrictions. Be like, hey, the Black Code happened for a couple of different reasons. One, at that point in time, black people were not considered American citizens. So that was not a gun law against American citizens. Two, that was a state restriction. The NFA is not a state restriction, that is a federal restriction. So maybe there might be some sort of historical context for a state restriction, but that does not apply to the NFA because the NFA is a federal restriction. And again, let's circle back. The only reason it was allowed to stand is because black people weren't considered American citizens. Then they might go ahead and bring up Indians being restricted from firearms, and they were, like, all the way back. Again, Americans did not get restricted. Indians were not considered an American citizen until 1968. That's when they got their civil rights. That's where they were officially recognized as American citizens. So that particular restriction was not against American citizens. Second, that was usually a state-by-state basis. Now, they did have federal restrictions on Indians for guns, but again, the only reason they could stand is because they were not considered an American citizen. And remember, the only time the NFA was challenged was in 1939. It has zero Supreme Court backing behind it. It has never once been affirmed by the Supreme Court that the NFA or GCA is in fact constitutional, because anytime somebody chooses to fight against the NFA or GCA, they make the case moot by throwing it out or dismissing it. So, the only thing that was affirmed was in 1939, and that is that a short barrel shotgun has no military use, which, as we all know, it most certainly does, and it is being used today by the military. So everything that was said in 1939 about it being constitutional no longer stands, because short barrel shotguns are most definitely used by the military, and they said specifically, we're not talking about if the NFA is or is not constitutional. In this particular case, we're only talking about if the Second Amendment covers a short barrel shotgun, which we have decided does not, because it doesn't have a military use. Because they didn't back then. All the shotguns back then had over an 18-inch barrel in the military. But, so it's very important to bring up There is no Supreme Court standing that the NFA or GCA is in fact constitutional. Anytime a case that's even remotely resembled the Second Amendment, the Supreme Court has always ruled the Second Amendment cannot be infringed. Again, whether that's Miller, Heller, McDonald, it doesn't matter. The Supreme Court has always ruled in favor of the Second Amendment because it clearly says shall not be infringed. They'd let some stuff go using the two-step balancing process, but that's gone. Now you can only use text, tradition, and history. So that's why you're seeing a lot of people getting attacked in my comment section, is because there is a pile of anti-gun people watching my videos just biting at their nails, hoping and praying that somehow my case goes away because, yeah, that's bad. That is a really, really bad case to have go up to the Supreme Court. And they're trying to talk people out of not looking at text, tradition, and history because that's the only thing that's relevant. They want to be able to show up in a courtroom and bring up the black code and trump up the lawyer or trip up the lawyer and make him go, oh, I guess you're right. I guess there is some sort of tradition and history. No, you got to understand the facts around it, especially if you're now in the legal system fighting one of these things. Do your research. Do all your homework. If you find some little piece of nugget information that you haven't heard about before, make sure that gets to a Pro 2A YouTube channel so they can talk about it, so everybody knows about that piece of information. Because our armor is just growing and getting stronger by the day as more and more people research things, bring information into the forefront. It's casted among the population. Because, face it, there is no gun law, none at all, that is constitutional under the Second Amendment. Show me where. Show me, like, seriously, in the comment section, one of you anti-gun people, show me exactly where in the Second Amendment does the government get afforded the power to restrict anything in any way, shape, or form. I would seriously like to hear it. Maybe it's really small and I can't see it. You know, I don't have my glasses on, so I guess that's a possibility. Or maybe it's written in invisible ink, but it clearly says, shall not be infringed. Anywho, if you'd like to help support the channel, got my Patreon right there. Also have affiliate links in the description down below. Just by clicking on that particular link. That's it. You just got to click on it. You don't even have to buy what that link takes you to. Just clicking on that and doing the Amazon shopping you were already going to do anyway. I'll kickback for it because you came there off my channel. Thank you for watching. Don't forget to subscribe.